If you thought courtroom chaos needed a little seasoning, buckle up because this one comes pre-marinated in delay tactics, threats, ego, and absolute procedural whiplash. Today's case centers on a defendant who seems determined to fight literally everyone in the room except the actual charges in front of him. He wants his lawyer gone, then maybe not gone, then gone again. He wants the judge recused. He wants to argue about fairness, timing, bias, representation, investigations, procedure, and just about everything except how his own conduct keeps detonating the schedule. And the wild part? This is not a high-speed dramatic trial moment with surprise evidence and a Perry Mason reveal. This is a preliminary stage hearing where the court is just trying to figure out whether there's enough to move forward, and even that becomes a full contact sport. What makes this hearing so fascinating is the collision between legitimate legal concepts and spectacularly self-defeating behavior. We're going to hear about alleged threats to guards and the prosecutor, a hearing derailed by security concerns, a claim that an outside investigation changes everything, a failed attempt to force the judge off the case, and one of the most frustratingly common courtroom myths of all: nobody knows my case better than me, so I should represent myself. That line almost never lands the way defendants think it does. So as we get into this, keep one question in mind. Is this man being railroaded by the system, or is he personally bulldozing every chance he has to move this case forward? Because by the end, you may find the real story here isn't just what the court does, it's what happens when someone confuses talking the most with having the strongest legal position.
Mr. Niegos, are you able to see and hear me?
Yes, Judge.
This is case number 253691 FY, the people of the state of Michigan versus Bobby Lee Du Bois. We were scheduled today for a preliminary examination. However, the court received some information regarding some security issues. One is it was relayed to the corrections officer that Mr. Du Bois threatened to punch the corrections officer. There was also a message that was intercepted by the corrections office through the communications system that was sent yesterday at approximately noon or 11:47 a.m., in which, from Mr. Du Bois' account, it says, listen, I don't care no more. Says don't watch what happens. I don't even come.
Right out of the gate, the court is making something very clear. This hearing is not being postponed because of some mysterious conspiracy or paperwork glitch. It's being pushed because the judge has been told there are credible safety concerns tied directly to the defendant's own conduct. We've got an alleged threat against a corrections officer, a violent message about going after a guard and even the prosecutor, and then, as the cherry on top, a reported injury from mule kicking a jail door. That is not normal courtroom inconvenience. That is a full-on security problem. And once threats enter the picture, the court's priorities change immediately. Before speed, before convenience, before anyone's complaints about delay, the court has to protect staff, attorneys, and everyone else in the building. And here's the irony that's going to define this whole case. The defendant immediately complains that the process is taking too long. But if your own words and actions are the reason transport, safety, and courtroom logistics become a problem, then you are not just stuck in the delay, you are manufacturing it. So let me ask you this. If someone keeps slamming the brakes and then yelling about traffic, how much patience should the court really have?
To court tomorrow because I'm going to flip out on this mother effer, and that is not what's said, but I'll clean it up. I'm going to show them a side they've never seen. If I could get within an inch of a guard or with that prosecutor, I'm going to effing choke the life out of her. Due to the security concerns, the court requested that corrections take certain precautions in which to bring Mr. Du Bois to the courthouse for his preliminary examination. However, the corrections officers could not do that because it's reported that Mr. Du Bois may have broken an ankle or a foot due to mule kicking a door.
Now we transition into hearing number 2, and the temperature has not gone down 1 degree. If anything, the stakes feel higher because the court is trying again to do something pretty basic procedurally: hold a preliminary examination on a meth possession and resisting/obstructing case. That's not a trial. This isn't guilt or innocence being decided. This is the court asking whether there's enough evidence to continue the case. But watch what keeps happening in hearings like this. Every side issue becomes the main issue. Suddenly, instead of a straightforward probable cause style proceeding, we're diving into recusal, investigations, attorney conflict, and performance complaints. This is exactly how cases get bogged down when one person in the room treats every hearing like an all-purpose grievance forum. Some of those grievances might sound serious at first blush, but timing matters in court, procedure matters in court, and if you throw every complaint at the wall during a prelim, the judge still has to separate what is legally relevant today from what belongs somewhere else later. That's what makes this next section so important, because now we're about to see whether the recusal argument has any real legs, or whether this is just a dressed-up attempt to change the referee mid-game.
So the court finds for good cause, due to security purposes, we are not having the preliminary examination today. That will be adjourned to a later date. Also, it's now determined because a threat has been made against the prosecutor, whether or not a special prosecutor will need to be appointed in this case moving forward. So that is going to potentially delay this case. We will reschedule it for, again, next week to see where we're at.
So we've rescheduled this 5 times already. That's why I'm in the situation
Mr.
I'm
Du
in.
Bois,
I've been patient with you, Your Honor. I have. We are 55 days into this.
For the record, I have muted Mr. Du Bois because he is interrupting the court proceedings. Counsel and I had that meeting in chambers before, and it was decided that this is how we were going to handle it. As I said, Ms. Carey is going to determine whether or not she needs a special prosecutor. Mr. Niegos, it's questionable as to whether or not he's the MFer that's referenced in the message as well. And it's my understanding he's going to make a determination as to whether or not he'll need to withdraw from the case also. Counsel, have I summarized what we've discussed and what's happened so far in this case? For the record, Mr. Du Bois has walked out of the security or out of the communications room.
Yes, sir.
You have, Your Honor, in the interest of efficiency and to alleviate some of the concerns that Mr. Du Bois started putting on the record, whether fair or otherwise, my plan was to have him briefly placed under oath and just inquire as to that simple fact. But I'm not sure that would be productive to do so today. I leave it to the court's discretion, but in terms of the court's question as to was that an accurate summary of what we discussed in chambers? It was.
All right. And for the record, Mr. Du Bois is back in the Polycom room. So for those reasons, the court does find good cause to adjourn today, and we will be back on a different date and see procedurally where we're at. We are adjourned. Thank you.
Thank you, Judge.
Let's pause here, because this is where courtroom reality collides headfirst with jailhouse strategy. The defendant wants the judge recused because the judge used to work in the prosecutor's office. On paper, that sounds dramatic. In practice, it's usually nowhere near enough by itself. A judge doesn't automatically become biased just because they used to be a prosecutor. If that were the rule, huge numbers of judges all over the country would have to step off criminal cases immediately. The key question is whether there's a specific conflict, specific prior involvement, or a concrete reason the judge cannot be fair in this particular case. And notice what the prosecutor is hinting at here. This starts to look a lot like judge shopping. In other words, if you don't like how the current judge seems to be handling things, you toss out a thin recusal argument and hope for a new face and a new vibe. Courts generally do not reward that. So while defense counsel dutifully puts the request on the record, you can practically hear him signaling, "I'm making the motion because my client wants it made, not because it's strong." Be honest, do you think this was a real fairness concern or a tactical attempt to hit reset?
Case number 253691 FY. Appearances counsel, starting with the prosecutor.
Joanna Carey for the people.
Good afternoon, Your Honor. Ryan Diego Superior on behalf of Brandon Du Bois.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case. Mr. Niegos, I know you had mentioned some issues before we actually got the case called. Is there anything you'd like to address on the record?
Yes, Your Honor. I would just ask my client to confirm. We had a discussion yesterday. He indicated some concerns about a potential change or a request that the court recuse itself such that a different district court judge would hear this matter given the court's prior employment status. In my discussion with Mr. Du Bois yesterday, my conclusion was that it was insufficient to even make the request, but I would just ask for the court to ask of my client at this point in time, or allow me to ask him, basically, Bobby, do you want me to ask the court to recuse itself at this point in time based on what you and I spoke about last night?
I do, and there's a couple other things that I would ask the court to hear me
No.
on before that as well. I'm not sure if the court.
The judge's denial here is textbook. Prior service as a prosecutor, standing alone, is not enough. And he even explains the practical issue. In that local area, if former prosecutorial work were disqualifying by itself, there might be almost no judge left to hear the case. That's a small community court problem, and it's real. He also says he doesn't remember prosecuting this defendant on any specific case, which further weakens the argument that there's some personal baggage driving the bench. Then we get another important procedural detail. The hearing is being conducted by Zoom because of the prior threats. That matters a lot. This is the court telling everyone, without fanfare, we are not pretending last week didn't happen. Security decisions are not punishment by themselves. They're often risk management. Add in witness sequestration, meaning witnesses are kept from hearing each other's testimony so they don't tailor their stories, and you can see the court still trying to run a normal legal process inside a very abnormal atmosphere. The system is bending over backward to keep this moving, but the tension in the room is obvious.
Is aware that there is an open investigation on the said officers that.
Okay.
were involved
Okay.
in
No.
this case.
No. We're not gonna do that. I'm on Zoom. We're not doing this. So if you believe that because Judge Wiggins was the prior Wexford County prosecutor and had worked in the prosecutor's office, are you asking me that I ask that he recuse himself, knowing that there's going to be a new judge that's going to be presiding, likely Judge Ransom, which is going to mean additional delays just to have this hearing done? You understand that?
I do.
Judge, based on my client's discussion yesterday, based on his representations today, understanding how clairvoyant, and I guess that's not the right word, just how candid and transparent this court is in terms of its beliefs. I'm not sure ultimately, Mr. Du Bois is of the opinion that, he was previously prosecutor or attempts at prosecution were such when you were either the elected prosecutor or you were in a...
And now we hit one of the biggest themes in this whole hearing. The difference between a defendant feeling something is crucial and the court deciding it is legally crucial right now. The defendant wants another adjournment because he says there's an investigation into the deputies involved in the stop, and he believes that investigation is central to his defense. His attorney, however, very carefully puts some hard truth on the record. Whether that investigation exists or not, he doesn't believe it is currently necessary to effectively represent his client at this stage. That is a major disconnect between lawyer and client. Also, listen to the lawyer's warning about the parole hold and dead time. In plain English, the defendant is sitting in jail regardless, so asking for delays doesn't suddenly create freedom or leverage. If anything, it just stretches out the process he claims to want resolved. That's why this moment matters so much. Sometimes a client thinks delay equals strategy. Sometimes it just equals more waiting. And when your own lawyer is telling the court, I'm asking for this against my advice, that's a giant red flag about where this relationship is headed.
Well, I don't think there's anything specific in that request other than that you were the prior prosecutor, and I don't think that alone is enough for you to recuse yourself, and it sounds a little bit like judge shopping on the defendant's part, frankly. So I would ask the court to deny the motion.
Thank you. Defendant's request for me to recuse myself is denied. I do not believe I have a conflict in this case nor a reason to recuse myself. If the sole reason to recuse myself was because I have a defendant in front of me in which I was the prosecutor prior, I will say, other than maybe one judge, there's not a judge in this 2-county area that would be able to hear the case. Additionally, I don't believe just because I was a prosecutor, both elected and a chief assistant, doesn't rise to the level of being recused. I will state before that I was a public defender. I will also state that while I am familiar with Mr. Du Bois' name, I can honestly say I do not remember one case that I prosecuted him on. So I don't believe we've risen to the level of a need to recuse myself.
Yes, Your Honor. Thank you.
Mr. Niegos, are you requesting to move forward then today with the preliminary examination?
Yes, Your Honor, please.
Any additional matters before we start?
I would just ask that the witnesses be sequestered.
Ms. Carey, do you have any witnesses? All right.
I don't.
I will order that any witnesses be sequestered. I will also state for the record, because we didn't do this before, Mr. Niegos appears by Zoom and Mr. Du Bois appears by Zoom from he appears by the Wexford County Jail. Due to some threats that were made last week, the court felt it best for court security purposes to conduct this hearing by Zoom. Ms. Carey, your first witness.
Thank you. The people called Deputy Shane Roloffs.
Your Honor, can me and my attorney have a moment in the breakout room, please?
Mr. Niegos, you want a moment?
Yes, Your Honor.
Mr. Niegos, have you had the opportunity to discuss matters with your client?
I have, Your Honor. I didn't get a full and complete opportunity to explain to my client what I'm about to say on the record because I didn't get a chance to speak. But essentially, my client's request is as follows. He wishes me to ask for an adjournment of this matter.
The judge's Brady and Giglio comments are a really interesting legal checkpoint here. For anyone unfamiliar, Brady issues generally involve evidence favorable to the defense that the prosecution is required to disclose, while Giglio deals more specifically with information that could undermine a witness's credibility. So when the judge says this sounds like some kind of Brady-style complaint, he's acknowledging the defendant is trying to frame the alleged deputy misconduct as potentially important impeachment or exculpatory material. But then comes the key procedural distinction. Even if that issue becomes real later, this is usually not where it gets fully litigated. A preliminary exam is not a mini-trial on every imaginable discovery dispute. And then timing swoops in like a wrecking ball. It's late, the witnesses are already there, and the court has to decide whether to keep going or not. So after all that argument, we're still not talking about the evidence on the actual charges. We're still orbiting around the side battles. That's the frustration of this case in a nutshell. Every route back to the main road somehow turns into another detour.
Because he has initiated as he calls, an investigation into the actions of the primary troopers who investigated him in this event. He believes that the results of that investigation are paramount to his ability to present a defense in this case. He's also instructed me to subpoena some guards from the local Wexford County Jail for, at this point in time, I'm not sure what reason that would be towards a preliminary examination, but that's nonetheless his request. And the thing I didn't get a chance to tell him is to remind him that as this entire proceeding is now pending, he has no bond. He will have no bond. He's sitting on dead time. There's a parole hold on him. And whatever this MSP investigation that is or is not happening, he believes that it is. I have no information or knowledge of, nor do I believe it's paramount to my ability to effectively represent him in this case. That being said,
this is the emotional explosion point, and it tells you almost everything about the defendant's mindset. He says his trial rights are being violated, says the judge is biased, says the judge and prosecutor are too friendly, says he already tried to fire his attorney, and then lands on the classic grenade toss. I want to represent myself. Who knows my case better than me? That line sounds empowering in movies. In real life, it usually means the case is drifting into dangerous territory. Knowing the facts of your own life is not the same as knowing rules of evidence, criminal procedure, motion practice, preservation of issues, cross-examination strategy, or how not to accidentally help the prosecution. And that's what makes this moment so dramatic. Buried inside the rant are a few issues defendants often care deeply about: fairness, being heard, not trusting appointed counsel. But the delivery is so chaotic and contradictory that it weakens whatever legitimate concern may exist. So here's the question for the comments. When someone raises a few potentially real complaints in the middle of a 10-alarm meltdown, how much of that survives the way it's presented?
my understanding is he wishes me that I ask for this adjournment, which I'm doing at his request against my advice. And I would ask that the court ask him directly if that is in fact the case, if he does in fact that this examination be adjourned once more, even though I'm here prepared to go forward today, despite his earlier complaints about how long it's taken to get all of this here. Thank you, Judge.
Mr. Du Bois, your attorney has placed on the record your request. Is that your request?
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter, and I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it can be pertinent to what we have going on. And I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's gonna be wrongdoing found, I believe,
So,
in
Mr.
regards to this. Yes, sir.
What is the nature, and I don't want you to get into the facts of it, but what is the nature of your complaint to Michigan State Police?
It's not the Michigan State Police, it's Deputy Roloff and Deputy
No,
King
but
of
you
the
said-
Grand Traverse
but-
County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King
Are you alleging
in
that they're
regards to the
untruthful?
drug, in regards to the
Defense counsel's response here is actually pretty restrained, and that's worth noticing. He's not grandstanding, he's not insulting his client. He's basically saying, if he wants me discharged, I'm fine with that. Legally and practically, that makes sense. Courts can't force a healthy attorney-client relationship into existence when communication has cratered. If the client keeps saying he tried to fire counsel, keeps undermining counsel in open court, and keeps signaling he doesn't trust the representation, eventually the court has to deal with that fracture instead of pretending it isn't there. What's especially telling is how the lawyer describes the relationship, not an upward linear one, which is one of the most diplomatic ways possible to say this representation has been a disaster. And then, right on cue, the defendant interrupts to argue with the lawyer about missed meetings. That interruption almost proves the lawyer's point for him. The breakdown isn't hypothetical, it's happening live, in real time, on the record in front of the judge. If you're the court, what choice do you really have at that point except to start over with new counsel?
possession. I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
Yeah, let's hear from his lawyer and see if he wants to partake in some communal window licking.
Absolutely not.
All right, Ms. Carey, any argument?
Can we have Ms. Chandler subpoenaed to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know some of that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week. And I don't want to have them come back for the 5th time next week. So if we're going to have it investigated, and not schedule it until we're certain that investigation is over, then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation. And I will admit it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But are you guys able?
I am.
The court and staff are
Your
willing
Honor,
to,
at this,
if the party, Mr. Du Bois, it's my turn now.
yes, sir.
If the parties are willing to hang over, we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough. And now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you know, you didn't have a prelim last week because of your own actions. And now you're asking for another an adjournment today.
That I did.
And
I'm not, that it was my fault. My child rights are being violated and you're just letting.
This section is one of the clearest examples of a judge trying to explain the limits of the court's power in plain language. The defendant keeps demanding a good DK attorney, more time, better communication, and a proper defense. On a human level, sure, everyone wants that. But the judge is explaining something DJ often hate hearing. If you are indigent and receiving appointed counsel, the court does not operate like a customer service desk where you can scroll options and pick your preferred lawyer package. There's a system, a roster, contracts, availability, conflicts, and finite people willing and qualified to take these cases. That DJ has no rights. He absolutely has a right to counsel. But a right to counsel is not the same thing as a right to the exact attorney, style, schedule, or relationship you personally want. That distinction is brutable but important. And the judge's joke about getting Perry Mason next time, or not, is really just his way of saying nobody can promise the next DJ will magically solve everything. If the core problem is personality and control, a new lawyer may not fix much at all.
It happened. That's why Ransom was going to throw it out the first time. What do you, like, I'm not being heard. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. Like, how am I getting an unbiased fair chance here? Furthermore, like I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me. At this point, I would like to dismiss Mr. Niegos under the, like, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions again, you know, for the officers. Like, none of this stuff, I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are, and every time I don't, I get pushed through this system and I get screwed around. I do. Like, and the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos.
I'm sorry, it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Your Honor, I obviously I'm yammering and stammering. I'm not entirely sure what to say. He's representing, he knows his rights. He's representing, he tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the note from last week. He indicated he was not referring to me or my firm. As such, I was going to continue with him based on his representations here today. I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, I take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
What about the interview between us that was scheduled yesterday? You've missed two.
Okay, Mr. Du Bois, this is
Mr.
Du Bois. This is the perfect example. He's saying that the communication process is broken down. He wants out, and yet you want to argue with him Why, I don't know, but you want to argue with him about
Because I
that.
want it on record why. I'm not just being disruptive. I'm stating what's going on.
Now we're in the territory of self-representation, and this is where courts get very careful. Yes, a defendant can have a constitutional right to represent himself, but it is not a casual checkbox. The judge has to make sure any waiver of counsel is knowing, voluntary, and intelligent. Translation: you don't get to bounce back and forth between I want a lawyer, I want to represent myself, and I want a lawyer to do the work while I also control the case. Because that last option is basically hybrid representation, and courts are usually not eager to run that circuit. The judge is trying to pin him down to a single answer. Do you want appointed counsel, or do you want to go pro se? And the defendant keeps drifting into a third category, wanting access, materials, legal resources, and some measure of control while still expecting counsel to exist in the background. That's exactly the kind of ambiguity courts don't like. The law wants a clear lane here. He wants the whole highway, and that mismatch is why this conversation keeps looping instead of resolving. At this point, the defendant is trying to soften the edges of his behavior by saying he's just animated by nature. He goes on rants, he has disabilities, and this is his life on the line. And to be fair, the stakes are real. Criminal cases are serious. People do get emotional. They do feel unheard. They do feel trapped by systems they don't understand or don't trust. All of that can be true, but there's another truth sitting right next to it. Once a hearing becomes dominated by your interruptions, contradictions, and complaints, your credibility starts draining out of the room. Judges hear emotion every day. What they're looking for is whether emotion is being turned into coherent legal requests. And that's the tragedy of this hearing. There may be pieces of what he's saying that resonate. 5-minute attorney meetings? Frustrating. Feeling unprepared? Frightening. Wanting someone to actually sit down and explain your case? Fair. But every one of those points gets buried under the avalanche. So what do you think hurts a defendant more? Having a weak legal argument, or having a potentially decent point delivered in the worst possible way?
That can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, the lawyer sees them for 5 minutes, they don't go. How much time have you spent on my case? Tell me some specifics in it. Your Honor, nobody can. That's why I'm raising such a fit about this. It's unconstitutional. You tell me that I'm getting a good defense by one of these lawyers that spend no time. He's on bodycam. We have not sat down one time and went over any part of my case. Not one. You tell me how that's constitutionally right and fair to my fair and speedy trial. Am I right to be represented by a decent attorney? I don't understand why you guys can't see what I see and what other people see. I don't get it. I'm not trying to waste time. I'm not trying to be disruptive. And you know what? I take full accountability for my actions, why I'm in these chains. And
no,
why
I wouldn't say that.
I
I wouldn't be saying anything about accountability or why you're in those chains before you fire me formally. Don't say that.
I want an attorney that will come here, sit down with me.
Mr. Du Bois, let me ask you a question. Mr. Du Bois, let me ask you a question.
Yes, sir.
Do you want an attorney, or do you want to represent yourself? Because you've said two different things now.
I want an attorney that will come here and that will go over my case and give me the time and respect that I get.
I have no control, Mr. Du Bois. I have no control over who the public defenders appoint. I have no control over how they conduct their interviews. I have no control over that. All that has been removed from the court back during the reforms that started the Indigent Defense Commission. I have no control over that. All I can do is, it sounds like, based on what Mr. Niegos has told me and what you've told me, all I can do is order that Mr. Niegos is removed from the case because there's been a breakdown of the attorney-client privilege. You might get Perry Mason.
This may be the most devastating part of the hearing, and it's devastating precisely because it's so calm. The lawyer finally puts his side on the record in detail. There were attempts at remote jail visits. Documentation exists. The first meeting happened and apparently ended badly because the defendant didn't like the defense assessment. Another visit was scheduled. Police reports were provided, and this was only a preliminary exam anyway. That last part matters. A prelim is not where every defense theory gets fully unpacked with theatrical precision. It's often a narrower procedural event than defendants expect, and the lawyer's closing is clinical in the best way. He's basically saying, I evaluated the case, I explained the motions I anticipated, I was ready to proceed, and the fact that my client dislikes the likely outcome does not equal ineffective representation. That is a huge difference. A lawyer telling you something you don't want to hear is not proof the lawyer is failing you. Sometimes it's proof the lawyer is being honest. This entire rebuttal sounds like someone who has dealt with accusations like this before and came prepared with receipts.
Next time, or you might get Barney Fife. I can't say who you're going to get next time, but I do not have an endless supply of attorneys. Do you understand that?
I do understand that, and I don't like. Am I not entitled to a good defense? Am I not? 5 minutes
You are
before
entitled
we
to a good
come
defense,
before
but
you, Mr. Wiggins. Go ahead, sir. I don't want to interrupt.
Thank you. You're doing a very interesting job of not showing that. As I said, I have no control over who is going to be appointed to you. And yes, you do have the right to counsel, but you also have the right to hire your own counsel if you are not happy with the counsel you.
The judge now circles back to the bias allegation, and this is another reality check about small town courts. He openly acknowledges that he and the prosecutor used to work together and had a friendly relationship, but he also explains that being in the same professional ecosystem does not automatically mean decisions are rigged. In smaller legal communities, everybody knows everybody. Prosecutors, defenders, judges, probation, corrections, these people cross paths for years. The legal standard is not whether they've ever had professional rapport. The standard is whether the judge can remain impartial in the case before him. What I find interesting is the judge leaves the door open. He doesn't say, never bring this up again. He says in substance, raise it with your next attorney, and if that attorney believes there's a real basis, file the motion and I'll hear it. That's actually a pretty measured answer. It's not defensive, it's procedural. So the big audience question here is this: do you think the judge handled the bias accusations professionally, or did the prior relationship with the prosecutor create enough appearance of unfairness that someone else should have stepped in?
Receiving. And where you're indigent, which is what you are, I can't just go start knocking on doors and saying, please represent this person. There are attorneys that are under contract and under hire with the Wexford Missaukee Public Defender's Office. I have no control over that. So I'm willing to release Mr. Niegos. It sounds like he's in favor of that. It sounds like you're in favor of that. But I have no control over who you're going to get next.
But
I want to make sure you're clear.
have control over how they conduct what like 5 minutes to go over. We haven't went over anything in my case. Nothing. Don't you have? Can you point me in the direction of who to complain to? It's not my fault. I'm indigent. Like.
I completely agree.
Who can I complain to so I can get proper and adequate representation?
Mr. Boys, if you would give me 5 seconds, can you do that for me?
Absolutely.
You can contact the public defender's office here. They can direct you in a way to make a complaint. As I said, this is not the old days where the court had control over the public defenders. I don't do that. I have no control over who gets appointed, the directions they take a case. That has been entirely removed from the court. That's between you, the state of Michigan, and the Public Defender Indigent Defense Commission. But based on what I'm hearing today, I will remove Mr. Niegos from this case. We will make another referral to the Public Defender's Office for the appointment of an attorney. We'll get everybody back here, but I'm not going to set it for next week. I'm going to put this off until it's going to be, and I'm not going to reset it for a probable cause conference. This case has gone on long enough. It's going to go right back to the preliminary examination. So because of that, I'm going to set it out a little bit longer. We'll go out at least 2 weeks. In the what?
28th of October.
The 28th of October. If the parties can agree and the court finds there's reasonable grounds to put this back on for a preliminary or a probable cause conference, I'll consider it. But it's going to go on the docket as a preliminary examination. Nor can I even guarantee that by the 28th, you'll have an attorney. I had another case today that's been almost 2 weeks, if I recall correctly, that they're still waiting for an attorney to take the case. So just so
at
you're
this
aware
time,
of all
can I
that.
represent myself until then?
I need to be convinced that you are able to represent yourself. Yes, you have a constitutional right to represent yourself, but that's not an all-encompassing right. The court has to be, and you can let the jail go as well. The court has to be convinced that that is a knowing and voluntary waiver of your right to an attorney, and that you have the wherewithal to represent yourself. So before I go ahead and do that, we have a process we're going to have to go through, but I want to be very clear. Are you asking to represent yourself, or are you asking to have court counsel appointed or indigent defense counsel appointed?
I'm asking to be able to have the resources to represent myself and look into my case law, and reference those things until an attorney is appointed so I can better represent myself.
Well, but see, therein lies the problem, because you can't represent yourself in between time of an attorney being appointed. If you've requested the appointment of an attorney, the attorneys can't talk to you, and I can't talk to you in very limited circumstances until you have an attorney appointed. So that's why this question is very clear. Are you requesting the appointment of an attorney, or are you wanting to represent yourself? You can't have it both ways, just so you're clear on that.
So I can't be granted access to a good legal law library so I can actively participate in my case until I have.
You can do your
defender.
own. You can have access to the law materials, but because you've requested a court-appointed attorney, you can't make any filings with the court, and you can't have any communication with the court or the prosecutor's office, except in very limited circumstances.
Okay. Yeah,
Does that
I
make
would like
sense?
to try to get an attorney a public defender that I can work with and that will come here, and to save time for you in the court, all I'm asking for is an attorney to come in, review my case with me, take an interest in my case, so I feel like I'm adequately represented, because at this point, I don't feel like I have been. You can't adequately represent somebody 5 minutes before they go into court, Mr. Wiggins. That's been my whole thing. That's been my whole case. That's why I'm frustrated. That's why I'm an animated person by nature. Anybody will tell you that. The people at the jail, anybody that knows me, I'm animated by nature. I don't mean disrespect by it. And yes, I do get on a rant sometimes, and I am long-witted, but that's because I suffer from disabilities.
But Mr. Boys, you've requested the appointment of an attorney, so the court can't hear that motion.
Well, but I asked him to do that before this, and do
Okay,
you see the problem that we keep running into?
But again, that's water under the bridge. I'm just telling you, moving forward, you can discuss that issue with your next appointed attorney. All right?
Okay. Yes, sir.
Okay, we are adjourned. Thank you. Now, Mr. Boys, you raised another issue, and that is a friendship between Ms. Carey and myself. And yes, well, Ms. Carey and I had worked together for a number of years. She was also my chief assistant prosecutor while I was the prosecutor. And yes, we did have a friendly relationship. But I will state, since becoming judge, I don't want to say that friendship has ended, but as far as Ms. Carey and I doing anything together, that has not happened at all since I was judge. The most time we spent together was a couple of weeks ago at a conference with 4 other persons, including Mr. Champion, the chief public defender, and the community corrections director. So as far as your allegations that I can't be impartial because of a friendship that I have with the prosecutor, I don't find that persuasive. I've ruled against Ms. Carey in a number of cases as the judge, and I've ruled in favor as the judge. I've also ruled in favor against all the other prosecutors. We're in a small community, and unfortunately, that's how small communities work. But I have the ability to separate myself from any friendship that I have with somebody to make sure that justice is carried out. And if you aren't feeling that that's being done, I apologize for that. But that's simply how it is. But you can certainly raise these.
So here's the professional bottom line on this case. What we just watched was not a final trial or a verdict on guilt. It was a procedural train wreck centered on whether the court could even get through a preliminary stage without the hearing collapsing into conflict. The first hearing was derailed by security concerns after alleged threats and disruptive conduct. The second hearing was consumed by a failed recusal request, an attempted adjournment tied to an alleged investigation of deputies, repeated complaints about appointed counsel, and a full-on breakdown of the attorney-client relationship. In the end, the judge denied recusal, refused to treat the alleged investigation as a reason to stop the prelim on the spot, removed defense counsel after finding the relationship had broken down, and kicked the case forward for appointment of new counsel and eventual return to preliminary examination. The broader implication is pretty simple. Defendants absolutely have rights, but rights still operate inside procedure, timing, and courtroom order. When every hearing becomes a battlefield over everyone except the underlying case, it gets harder and harder to separate legitimate complaints from self-inflicted damage. And that, more than anything, is what made this one so gripping. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.